The cease and desist letter claimed I'd violated a non-compete agreement. I'd never signed one. The letter arrived on a Tuesday morning. Standard legal letterhead, 3 pages of accusations. My former coworker, now running his own consulting firm, alleged I'd stolen client lists, breached confidentiality, and violated contractual obligations that prohibited me from working in the same industry for 2 years. The problem was simple. None of it was true. I'd worked remotely as a product manager for a software company based in Dublin. My contract was clear. No non-compete clause, no confidentiality restrictions beyond standard NDA terms. I'd reviewed every page before signing. I'd kept a copy. The coworker who sent the letter, Marcus Webb, had left the company 6 months before I did. He'd launched a competing firm. He'd taken 3 clients with him. Management had done nothing. When I resigned 3 months later to join a different company, he'd sent the letter within a week. The accusations were detailed, specific, professional, completely fabricated. He claimed I'd signed an amendment to my original contract in February. He claimed the amendment included a non-compete clause. He claimed I had acknowledged the terms in writing. I checked my files. No amendment existed. I checked my email records. No correspondence about any contract changes. I called my former employer's HR department. They confirmed my contract on file matched the version I had. No amendments, no non-compete. Marcus had invented the entire thing. But his letter had one critical flaw. My full name, Nicole Patterson, appeared in the signature block of his legal threat. He didn't know who I was. He should have checked. I had 3 law degrees, one from University College Dublin, one from King's College London, one from Georgetown. I'd practiced contract law for 8 years before transitioning into product management. I'd specialized in employment disputes and intellectual property. I'd left legal practice because I wanted to build products, not argue about them. Marcus had worked with me for 14 months. We'd attended the same team meetings. We'd collaborated on feature launches. He'd never asked about my background. He'd never looked at my LinkedIn profile beyond the current role. He'd seen product manager and assumed I was vulnerable. He was wrong. I didn't respond to the letter immediately. I read it 4 times. I highlighted every factual claim. I noted every date, every alleged contract provision, every reference to documents that didn't exist. The letter demanded I cease all employment activities with my new company within 10 business days. It threatened litigation if I failed to comply. It claimed damages in excess of 200,000 euros. The new company, a cloud infrastructure firm, had hired me as head of product 2 weeks earlier. My start date was 3 days away. I forwarded the letter to my personal email. I saved it in 3 separate locations. I did not forward it to my new employer. I did not contact Marcus. I did not post about it publicly. I waited. On day 2, I received a second email. It was from Marcus directly. No legal letterhead this time. The tone was casual, almost friendly. He said he understood the letter might have seemed harsh. He said he was just protecting his business interests. He suggested we could resolve this without involving lawyers, if I agreed not to work for any competing firms for the next 18 months. He offered to withdraw the cease and desist if I signed a new agreement. I opened it. The agreement was 7 pages long. It prohibited me from working in product management, consulting, or any software-related role for 2 years. It required me to disclose all client contacts I'd made during my previous employment. It included a liquidated damages clause of 50,000 euros if I breached any term. It was more restrictive than any legitimate non-compete I'd ever reviewed. I saved the email. I saved the attachment. I didn't reply. On day 4, Marcus sent a follow-up. He asked if I'd reviewed his proposal. He said the offer would expire in 48 hours. He said if I didn't respond, he'd have no choice but to proceed with formal litigation. I checked the original cease and desist letter again. The law firm listed was a small practice in Cork. 2 partners. No employment law specialists on their website. They handled conveyancing and estate planning. Marcus had hired a general practice firm to draft a legal threat about contract law. That was useful information. I still didn't respond. On day 6, I received a message from my former manager at the Dublin company. Her name was Siobhan. We'd worked together for 2 years. She'd been supportive when I resigned. She'd written a strong reference letter. Her message was brief. She said Marcus had contacted her, asking for confirmation of my employment dates and contract terms. She said she'd referred him to HR per company policy. She wanted to give me a heads up. I thanked her. I asked if Marcus had made any specific claims about my conduct. She said no. He'd only asked for employment verification. I asked if HR had provided him with any documents. She said HR wouldn't release anything without a formal legal request or my written consent. I thanked her again. On day 8, my start date at the new company arrived. I reported for onboarding as scheduled. I completed the paperwork, I attended orientation, I met my team. I said nothing about the cease and desist letter. The new company's HR director, a woman named Fiona, asked if there were any legal issues I needed to disclose. Standard question for new hires. I said there were none that would affect my employment. That was technically true. The cease and desist had no legal standing. There was no valid non-compete. There was no breach. Fiona accepted my answer and moved on. On day 10, the deadline Marcus had set in his email passed. No new messages arrived. No lawsuit was filed. No further contact. I checked the Irish court records daily. Nothing. I waited another week. Still nothing. Marcus was bluffing. He'd sent a threatening letter hoping I'd panic and resign. When that failed, he'd tried to pressure me into signing an even more restrictive agreement. When I didn't respond, he'd gone quiet. But he hadn't withdrawn the letter. It still existed. It still made false claims about fabricated contract amendments. I needed to address it properly. I spent 3 weeks building my case. I started with the original contract. I'd signed it 28 months earlier. It was a standard fixed-term employment agreement with automatic renewal provisions. Page 6, Section 9 outlined confidentiality obligations. Standard NDA language. No non-compete clause. Page 7, Section 10 outlined termination procedures. Either party could terminate with 30 days' notice. No penalties. No restrictions on future employment. Page 8, Section 11 outlined the amendment process. Any changes to the contract required written notice from both parties, signature by authorized representatives, and formal acknowledgement. No amendments had ever been proposed. No written notices had been sent. No signatures had been collected. I printed the entire contract. I had it notarized. I had a solicitor certify that it matched the version on file with my former employer. Next, I compiled my email records. I exported every message I'd sent or received during my employment. 12,000 emails total. I filtered them by sender, subject, and date. 0 emails from Marcus or HR mentioned contract amendments. 0 emails referenced non-compete clauses. 0 emails discussed restrictions on future employment. I created a sworn statement attesting to the completeness of the email archive. I had it witnessed by a commissioner for oaths. Then I contacted my former employer's HR department. I submitted a formal subject access request under GDPR. I requested copies of all employment records, all contract documents, all HR communications, and all amendment records related to my file. The company had 30 days to respond. They responded in 18. The records they provided matched exactly what I already had: original contract, performance reviews, resignation letter, exit interview notes. No amendments, no non-compete, no modifications of any kind. I had an official confirmation from the employer that Marcus's claims were false. Finally, I reviewed Marcus's business registration. His consulting firm, Web Strategic Solutions, had been registered in Ireland 4 months after he left our former employer. The registration listed him as sole director. The business address was a virtual office in Dublin city centre. I checked his website. It advertised services in product strategy, market analysis, and client development, the same services our former employer provided. I cross-referenced his client list against the contacts I'd worked with. 3 clients he claimed on his website had been managed by our team. He'd taken them when he left. Our former employer had a policy against soliciting clients within 12 months of departure. Marcus had violated it. But that wasn't my concern. I wasn't seeking to damage his business. I just needed to establish a pattern. I assembled everything into a single document package: original employment contract with notarization, email archive with sworn statement, GDPR response from former employer, timeline of Marcus's communications, copy of the fabricated cease and desist letter. I drafted a formal response letter. I addressed it to the law firm Marcus had hired. I identified myself by full name and credentials: Nicole Patterson, LLB UCD, LLM Kings, JD Georgetown, former solicitor admitted to the Law Society of Ireland. I stated that I was responding to their cease and desist letter, dated 3 weeks prior. I stated that the letter contained multiple factual inaccuracies and legal misrepresentations. I outlined each false claim systematically: the non-existent contract amendment, the fabricated non-compete clause, the baseless allegations of breach. I attached documentary evidence disproving each claim. I noted that under Irish law, making false statements in legal correspondence could constitute abuse of process. I noted that threatening litigation without legal basis could constitute harassment. I stated that I expected a full retraction and written apology within 7 business days. I stated that if no retraction was provided, I would file a formal complaint with the Law Society of Ireland regarding the firm's professional conduct. I also stated that I would pursue civil remedies for defamation and malicious falsehood. I kept my tone neutral, clinical, professional. I sent the letter via registered post to the law firm. I sent a copy to Marcus at his business address. Then I waited. The law firm responded in 4 days. The letter was signed by one of the partners, a man named Dermot Quinn. His tone was markedly different from the original cease and desist. He stated that his firm had relied on information provided by their client, Mr. Webb. He stated that they had not independently verified the existence of the alleged contract amendment. He stated that, upon review of the evidence I'd provided, it appeared there had been a misunderstanding. He did not use the word fabrication. He did not acknowledge that Marcus had lied. He stated that his firm was withdrawing the cease and desist letter, effective immediately. He stated that they would send written confirmation to my current employer that no legal claims were being pursued. He did not offer an apology. He asked if I considered the matter resolved. I did not. I replied to Dermot Quinn, stating that withdrawal of the letter was insufficient. I stated that the original letter had made specific factual claims that were demonstrably false. I stated that those claims had been made in writing, on legal letterhead, and presented as established fact. I stated that I required a formal retraction letter that explicitly acknowledged the following: no contract amendment was ever executed. No non-compete agreement exists. I had not breached any contractual obligations. The original cease and desist letter was issued in error, based on inaccurate information. I stated that the retraction letter must be sent to me, to my current employer, and to my former employer within 5 business days. I stated that if this did not occur, I would proceed with filing a formal complaint with the Law Society and would pursue civil litigation for defamation. Dermot Quinn responded within 24 hours. He agreed to all terms. The retraction letter arrived 6 days later. It was addressed to me with copies to both employers. It contained all 4 acknowledgments I'd requested. It stated that the original letter had been issued in error due to incomplete information provided by the client. It was carefully worded to avoid admitting fault by the law firm itself, but it served its purpose. I forwarded the retraction to Fiona in HR at my current employer. She acknowledged it and confirmed there would be no employment concerns. I forwarded it to Siobhan at my former employer. She replied saying she was glad it had been resolved. I saved everything in my legal records folder. Segment 4. Marcus sent me an email 2 days after the retraction was issued. He didn't apologize. He didn't acknowledge the false claims. He didn't explain why he'd fabricated a contract amendment. He said the whole situation had been an unfortunate miscommunication. He said he hoped we could move past this professionally. He said he wished me well in my new role. I didn't respond. 3 weeks later, I received a message from a former colleague at the Dublin company. He worked in business development. He said Marcus had reached out, asking if the company would consider a partnership arrangement. He said management had declined. He didn't say why. He didn't need to. Word had spread. In month 2 at my new position, I attended an industry conference in Amsterdam. Marcus was speaking on a panel about product strategy. I saw him in the hallway during a break. He saw me. He looked away. He walked in the opposite direction. I attended his panel session. I sat in the 3rd row. I took notes. His presentation was generic, surface-level insights, nothing substantive. When the Q&A opened, I didn't raise my hand. I didn't need to say anything. 6 months after the retraction, I received a settlement offer. It came through a different law firm, a larger practice in Dublin that specialized in commercial disputes. The letter was addressed to me personally. It was marked without prejudice. The firm represented Marcus Webb. They stated that Mr. Webb wished to resolve any outstanding issues arising from the previous legal correspondence. They offered a financial settlement of €15,000 in exchange for a mutual non-disparagement agreement. The agreement would prohibit both parties from making negative statements about each other. It would include a confidentiality clause. It would constitute full and final settlement of all claims. I reviewed the offer. €15,000 was a modest sum. It wouldn't cover my time or the stress of dealing with the false accusations. But it was an acknowledgement. Marcus was paying to make the problem go away. More importantly, he was admitting liability. Settlement offers are only made when someone believes they might lose in court. I drafted a counteroffer. I accepted the settlement amount. I accepted the non-disparagement clause. I rejected the confidentiality provision. I stated that I would not publicly discuss the settlement, but I would retain the right to disclose the facts of the original cease and desist letter if asked by professional contacts, employers, or regulatory bodies. I stated that this was non-negotiable. The law firm responded 10 days later. Marcus accepted the terms. The settlement agreement was executed in early December. The payment cleared within 5 business days. I deposited it into a savings account. I didn't spend it. I didn't need it. I kept all the documentation: the original cease and desist, the retraction letter, the email records, the settlement agreement. I kept them because Marcus had tried to destroy my career with a fabricated legal claim. He'd assumed I wouldn't know how to fight back. He'd assumed wrong. I stayed at the cloud infrastructure company for 2 years. I built a strong product portfolio. I received 2 promotions. I hired a team of 12. I had no legal issues, no contract disputes, no problems. Marcus's consulting firm closed 18 months after the settlement. The website went offline. The business registration was dissolved. I don't know what happened. I didn't follow up. I moved to a director-level position at a different company last year. Better compensation, broader scope, more autonomy. During the interview process, they asked if I had any legal issues to disclose. I said no, because I didn't. I still practice law occasionally. Pro bono work for employees facing wrongful termination. Contract reviews for friends starting businesses. Consultations for people who've received questionable legal threats. I tell them the same thing every time. Read everything. Document everything. Know your rights. Don't assume the other side knows what they're doing. Most legal threats are noise, but you have to call the bluff properly.